Thanks for staying with us here on the Market Day Report. Good morning. I'm Suzanne Alexander. Well, the U.S. Tax Court has released a recent opinion of importance to agriculture involving everything as co-op taxation. And the IRS has provided guidance on conservation easement donations. We're going to turn to the impact on the farmers and ranchers. Roger McEowen with Washburn School of Law joins us now to break it down for us. Love having you here, Roger. Of course, we're going to talk about this first case. Involves computation of tax liability for an ag cooperative. Give us a little recap on this one.
Yeah, good to be with you, Suzanne. This one is quite complex. Of course, co-op taxation is very difficult in and of itself. But what this is, let me break it down as simply as I can. This involved an ag supply co-op that also blended fuel. And the tax court said that they could claim tax credits, of course, under the code for fuel mixtures that they blended, and then they could reduce its taxable income by the cost of goods sold, incurred or paid, not by its gross excise tax liability, unreduced by the tax credits received. So what does all that mean? What it means is the IRS has previously taken the position that when there's no actual excise tax liability that a blender has, a purely refundable fuel tax credit, which is what they were claiming, doesn't reduce any deduction for fuel or create any addition to income. The tax court said that's right, agreeing with the IRS position.
So what do people need to take away from this case? I mean, what should they know about this?
Yeah, well, the rule now is solidified by a full tax court opinion. And the facts of the case didn't allow the tax court to address the situation where the entity that generated the fuel tax credit is separate from the activity generating the excise tax liability. So there are two things there. And what I think co-ops could do, and this is the take home out of this, is structure their business a little bit differently. And I think they're going to get the result that they want out of this. But if you've got the same entity claiming the credit that's blending the fuel, the tax court is saying, no, you can't get the tax benefit that you want.
Well, another big topic here, conservation easement donations. Talk about the highlights here.
Yeah, this is huge. I've seen some of these cases exceed $50 to $60 million in terms of the charitable deduction that's involved. Because what you can do, if you got a farm or a ranch that's in a scenic area, you can donate a conservation easement over a part of that, or maybe even all of it, to a land trust or some type of qualified land trust and get a big tax deduction, a charitable deduction. IRS jumps all over this kind of stuff. They are really nitpicky on all of these. They audit every one of those. And so if you change anything, or you have the right to change anything after the donation is made, such as the boundary that demarcates the easement area, or maybe there's an eminent domain action taken by the state or some type of governmental entity that extinguishes the easement, there has to be very specific language in the deed that's granted to the conservation entity. And IRS has now given a safe harbor language that we can put in those deeds.
A lesson here for farmers, ranchers? Is it just dot every I, cross every T here?
Absolutely. This is a huge audit issue. I'll be frank with listeners, and that is IRS absolutely hates this technique. So you have to be very, very careful. They will try and find anything they possibly can to deny the charitable deduction. So experienced tax counsel that's done these before is an absolute must.
Thank you, Roger. As always, great insight. Well, I can't do this without you. Roger McEowen with the Washburn School of Law. Always appreciate you joining us.